Okay, just now we have fulfilled the three elements of negligence. So if the three elements have been fulfilled, then plenty is likely to win the case, right? Okay, however, there are several defenses available to the defendant. Okay, maksudnya defendant dia boleh guna defense. Okay, in order to prove that uh, he is not liable for negligence. Okay, the general rule of this defense is the burden of proof lies on the defendant to negate liability for a particular tort. So defendant must prove. Okay, defenses usually raised in negligence suits. Okay, for example, voluntary not fit injuria, contributory negligence, exclusion clause. There are three importance defenses that you need to know. And then inevitable accidents is something that you cannot avoid. And then act of God, for example, that the defendant himself cannot control, and it caused by the force of nature, so outside of human control. For example, storms happen, okay, gempa bumi, right? And then defense of necessity, okay. But for the purpose of um negligence, okay, we are going to focus these three defenses only. Right, first is defense of voluntary non-fit injuria. Okay, this maxim means the plaintiff has voluntarily assumed the risk of injury. Okay, selalunya dia sendiri yang volunteer to the injury. Okay, the claimant voluntarily agrees to undertake the legal risk of harm at his own expense. For example, okay, this defense applicable to master and servant cases, games and sports, rescue, okay, and passengers. For example, you may refer to the case of Dan against Hamilton. In this case, the plaintiff had accepted a lift in a car driven by a drunk driver. She was injured as a result of his driving. So the court held that the defense of voluntary non-fit injuria failed because the fact showed that although he was drunk, he was not so drunk as to be incapable of taking care, and the plaintiff was not deemed to have consented to carelessness on his part. So in this case, the defendant, okay, the intoxicated person failed to use this defense, okay, because he was not 100% drunk at that time. So they still ada capability to take care of the plaintiff. And the second defense that available to the defendant is contributory negligence. Failure by the plaintiff to take reasonable care of himself or his property which consequently contributed to or resulted in his injury. Dia sendiri contribute to the negligence. Okay, the elements. First, the plaintiff is required to act reasonably to avoid damage to himself. The plaintiff breached this duty by behaving unreasonably, and the act of the plaintiff must be the cause of his injury. In other words, plaintiff sendiri yang menyumbang kepada negligence tu. Okay. Based on section 12, subsection 1 of the Civil Law Act 1956, where any person suffer damage as a result partly of his own fault and partly of the faults of any other persons. So this is to show the contributory negligence. Okay, so the damage shall not be defeated by reason of the faults of the person suffering the damage, but the damages recoverable in respect thereof shall be reduced to such extent as the court thinks just and equitable, having regards to the claimant's share in the responsibility of the damage. Okay, so if the defendant is able to sort for this damage, kalau defendant berjaya gunakan this damage of contributory negligence, dan akan ada pengurangan dari segi monetary compensation. Dia tetap liable for negligence, cuma dia akan dapat pengurangan bayaran ganti rugi kepada plaintiff. Okay. Okay, example of case of contributory negligence. The case of Santanelchemi AP Subramaniam against Zainab bin Sa'an and another. A 12-year-old girl was held to be sufficiently mature and could have prevented or avoided the accident when the defendant lorry driver honked his lorry. She was found to have been contributory negligence 20% and the defendant 80%. So the monetary terms, monetary damages, okay, may be reduced by the court. And the next defense available to the defendants is exclusion clause. Can liability be excluded by giving notice to the plaintiff? Only if the clause is construed as clear and ambiguous. Ambiguous means that without any ambiguity, maksudnya tak ada any kekaburan. Okay, so defendant may escape liability. Okay, in the case of Chin Hui Nan against Comprehensive Auto Restoration Service Sendirian Berhad, so the plaintiff car was damaged due to the defendant's employee's negligence. There was a clause behind the receipt issued to the defendant. The company is not liable for any loss or damage whatsoever of or to the vehicle, its accessories or contents. Vehicles and goods are left at owner's risk. Okay, this statement shows that the defendant had provided exemption clause or exclusion clause to the plaintiff. Okay. However, the court held that this notice still insufficient. Defendant must show that they had exercised due diligence and care in handling plaintiff car, which defendant failed to do. So maksudnya the notice itself must be very clear and unambiguous. Barulah defendant may escape from the liability. Okay. So that's all for today. I hope that you are able to digest the three elements of negligence plus the defenses that are available to defendant. Okay, so please remember one case for each element of negligence. If you have any question or certain term yang you guys tak faham, you may directly message me. Okay, so thank you for your great attention today. Assalamualaikum.